19(1) F, and Article 31 Arc excluded. But fundamental rights belonging to the minorities and religious groups are also excluded. The article purports to save laws which a state may make towards securing the principles specified in Clause B or C of Article 39 from being challenged on the ground that the law is inconsistent with or takes away or abridges any of the rights conferred by Articles 14, 19, or 31. This is the only ground on which they cannot be challenged. 99. The article provides that if the law contains a declaration that it is for giving effect to such policy, it shall not be called in question in any court on the ground that it does not give effect to such policy. In other words, once a declaration is given, no court can question the law on the ground, and that it has nothing to do with giving effect to the policy. Whether it gives effect to some other policy is irrelevant. Further, a law may contain some provision dealing with principles specified in Clause B or C of Article 39, while other sections may have nothing to do with it. Yet on the language it denies any court power or jurisdiction to go into this question. In the FTCC of the desideration, this court would be unable to test the validity of incidental provisions which do not constitute an essential and integral part of the policy directed to give efficacy to Article 39B and Article 39C. 200. Article 31C DFCRs in nature from Article 31A. In Article 31A, the subject matter of the legislation is clearly provided, namely, the acquisition by the state, PF, any estate or any rights therein, art. 31A, J. Similarly, the subject matter of legislation is specifically provided in clauses B, C, and D of Article 31A. But in Article 31C, the sky is the limit because it leaves it to each state to adopt measures towards securing principles specified in clauses B and C of Article 39. The wording of Articles 39B and 39C is very wide. The expression economic system in Article 39C may well include professional and other services. It would be difficult to resist the contention of the state that each provision in the law had been taken for the purpose of giving effect to the policy of the state. 201, 222. In effect, Article 31C enables states to adopt any policy they like and abrogate Article 14, 19, and 31 of the Constitution at will. Parliament cannot under Article 368 abrogate fundamental rights. Parliament equally cannot enable the legislatures to abrogate them. This provision enables legislatures to abrogate fundamental rights and therefore must be declared unconstitutional. 4. Article 368 of the Constitution itself provides that amendment may be initiated only by the introduction of a bill for the purpose in either House of Parliament in other words, Article 368 docs not contemplate any her mode of aminal, LCN by patly ill, LT acutit docs not equally contemplate Parliament to set up and body to acion the Constitution. It is ill settled, i.e. India, that Parliament can ruit delegate its essential legislative functions, P-Injaf 2 SVPUMKCOO, TL Ports, 1973, Supska. Since the state legislates under Article 31C and the law abrogates, or takes away fundamental rights, the 11, cease to have any effect. The amendment do not then made by Parliament, as the extent of the amendment is not known till the state legislates. It is when the state legislates that the extent of the abrogation or abridgment of the fundamental rights becomes clear. To all intents and purposes, it seems that it is state legislation that effects an amendment of the Constitution. If it be assumed that Article 31C does not enable the state to amend the Constitution, then Article 31C would be ineffective, because the law which in effect abridges or takes away the fundamental rights would have been passed, not in the form required by Article 368, that is by 2/3 majority of the Parliament, but by another body, which is not recognized in Article 368, and would be void on that ground. Ps. What Article 31C does is that it empowers legislatures subject TN, the condition laid down in Article 31C itself, to take away or abridge the rights conferred by Article 4, 19, and 31. At any rate, if it is to be deemed an amendment of Article 368, it is beyond the powers conferred by Article 368 itself. Article 368 docs not enable the Parliament to constitute another legislature to amend the Constitution, in its exercise of the power to amend Article 368 itself. For the aforesaid reasons, it must be held that Section 3 of the U.S. Constitution 25th Amendment Act is void, as it delegates power to the legislatures to amend the Constitution. Balkan Akadazi Padan v. State of Orissa, 1963. Sup 2 SCR 691707 RC Co-op v. Union of LNDU. 1973 SCR 53582. In Rel Nitilive and RQL1 Endem Act, 1919, AC 935, Attorney General of Nova Scotia v. Attorney General of Canada, 1951, SCR Canada, 31, Nadan vi. The King, 1926.